Well, as you heard, the Supreme Court of Canada has upheld the country's law against possession of child pornography. But it made two exceptions. The first is for written material or drawings that someone creates, if that material isn't intended for anyone else's eyes. The second is for videos or photos consenting people take of themselves, again, if they're not intended for anyone else's eyes. Many Canadians, including civil liberties groups, victims' rights advocates, politicians, and lawyers, are debating the merits of the decision. Tonight, some of the voices on both sides of that debate. Thought control and legislative overkill, or a vital tool to protect our children? John Sharpe's trip to the Supreme Court not only challenged Canada's child pornography law, it raised a debate about things most precious and important to Canadians: children and fundamental democratic freedoms. The court justices themselves, while accusing some interveners of inflaming the debate, acknowledged the difficult line to be drawn between protecting children from harm and protecting the rights of freedom of speech and expression allowed John Sharpe and every Canadian. So how did they do? Brenda Kosman is a law professor at the University of Toronto. In your view, is it a good judgment?
Well, I think that the judgment basically addressed the very, very worst parts of this law. It looked at the parts of the law that really were the most egregious violations of freedom of expression by carving out an exemption for material that is purely the product of someone's imagination written down simply for their own use, and material that an individual makes that involves themselves also for their own use. And so really what the court has done here is carve out an exception for materials that are purely the product of one's imagination or purely the product of one's own activities, as long as those aren't illegal.
We have to hope that law enforcement will understand that the court was attempting to put a brake and put some limits on how this law would be used.
Frank Addario represented the Criminal Lawyers Association in this case at the Supreme Court. He too says the child pornography laws enacted by Parliament went too far in trampling individual rights. Addario was the lawyer in a high-profile case prosecuted under the new law. Toronto artist Eli Langer was charged after a gallery displayed his paintings. The charges were eventually dropped. What do you actually think it'll mean for artists? I mean, I know you defended Eli Langer, so what would it mean for someone like him?
Well, I don't think it would provide any comfort at all to someone who wanted to explore controversial themes like teen sexuality or the abuse of children in their art. I think they're as at risk today as they were yesterday of being prosecuted for that by a zealous police officer.
At the same time, the argument on the other side is that when it comes to protecting children, that the value of freedom of expression at this level, I suppose, that there is so low that in a sense it's not worth protecting.
Well, look, if it could have been shown, and if it had been shown, that the private possession of material that falls within the definition of child pornography here always universally created harm, then of course the law should have been upheld in all forms. But because the law was so poorly drafted and so broadly written, that wasn't all that was captured by this prescription. And so it kind of misses the mark to say, well, this is low-value speech. It wasn't just low-value speech that was caught. And the second reason it misses the mark, I think, is because privacy is also a value. It's not just the quality of this material. It's also about people reducing their innermost thoughts to paper, for example.
But for some, even those private thoughts, which John Sharpe had collected and formed part of the case against him, are a clear danger. Tim Danson argued in favor of protecting the law in front of the Supreme Court. What's the link, then, between the thought and the imagination that people have talked about in connection with this case and the actions of a pedophile?
Well, the empirical research shows that, first of all, if a pedophile starts thinking about having sex with a child and starts writing it down, more often than not, it's not a product of the imagination. Indeed, he's writing about an experience that he has already had. Further, if he hasn't had the experience, which is highly unlikely, he will fantasize about the imaginations that he's putting to writing or sketching or what have you. And the evidence is clear and it's unequivocal, which is that it will fuel their fantasies and they will act out. And so the reason why possession becomes so important is that the harm is in the use that a pedophile will make of this material in grooming children, tricking children into thinking that sex with adults is normal, and indeed using it to act out fully in their sexual fantasies.
Some justices, in fact, felt the entire law should have been upheld, that there should be no exceptions. Given the low value of the speech at issue in this case, they wrote, and the fact that it undermines the charter rights of children, Parliament was justified in concluding that visual works of the imagination would harm children. Evidence suggests that the cognitive distortions of pedophiles are reinforced by such material, and that written pornography fuels the sexual fantasies of pedophiles and could incite them to offend.
As a parent, I'm disappointed. I'm very delighted in the fact that the law was upheld, but the exemptions are way too broad.
Rosalind Prober is the co-founder of Beyond Borders, a group that fights child pornography. She would have preferred the whole court agree that there should be no exceptions to the law.
And if you look at this from a pedophile's perspective, they're now allowed to have material that is once used to be classified as child pornography. That is material where they've written it themselves, but it's still material that incites them, encourages them, educates them to sexually abuse children, like your neighbor.
Now, some people will say that can be used for grooming. It can be used to try and normalize sexual activity with children. And I'm concerned about that. There just isn't a lot of social science evidence that illustrates whether that's actually true, whether in fact that's a way that it is dominantly used.
But does it matter? I mean, the court has argued, in fact, in the judgment that it doesn't really matter whether or not that's proven or not. If there's a fear that that might happen, that's enough.
I don't think that we can go really on fear alone, because often I think we are scared of many, many things, and that's precisely the moment where civil liberties are at risk, and where we may run roughshod over civil liberties.
This isn't about thought control, although the civil libertarians would like us to believe that. It certainly isn't. It's about balancing the rights of children to be free from sexual exploitation with the rights to individuals, adults, to liberty and freedom of expression, which they certainly should have, and we certainly believe that. But Beyond Borders and the other interveners asked the Supreme Court to surgically and with enormous precision carve that out, that portion of freedom of expression which is harmful to children. They failed.
There's a fine line to be drawn between, the sort of fundamental rights of freedom of speech and freedom of expression and protecting children from harm. And society has said that those two things are very, very important. From a philosophical point of view, tell me how you achieve that balance.
I achieve the balance in that the balance always must be in favor of protecting children. And wherever freedom of expression harms children and has the potential of putting children at risk, in a real sense, not some hypothetical risk, then the balance always must be in favor of the children. And those people who advocate that it's appropriate and healthy for adults to have sex with children, thank God, are a very, very small minority of people, and therefore, in the balance, their rights can't possibly trump that of the protection of children.
The courts and Parliament and Canadian society, too, have said that when we're protecting children, that the balance between protecting children and other kinds of freedoms should weigh more heavily in favor of the children. When they're trying to strike that balance, where do you think this court, this decision, walks that line?
Oh, it's clearly weighted on the side of protecting children from harm, and clearly anywhere where there's any doubt about this, it comes down in favor of protecting children. My own sense, again, is that that balance isn't quite right. I am absolutely in favor of protecting children from harm, and I'm not here in any way to defend child pornography or pedophiles. I'm concerned about people being thrown in jail for materials that are entirely the product of one's imagination. So I would balance this differently.
Do we believe in freedom of expression? Do we believe that it's integral to have that? Yes, we do. But we also have to deal with the victimization of children in this country, and we have to deal with it appropriately.
There's a question I think Parliament never confronted, which is, does the state really have a place in entering homes and then seizing this material and then putting such people on trial? So it's not just a question of children. I don't think the protection of children was the only value on the table, if you will, when this case got to Supreme Court.
About 100 cases involving possession of child pornography were put on hold while the Supreme Court considered this case. Today's ruling allows them to move forward.